Assalamu alaikum, welcome back to our channel, AI Era, Islamic and Abrahamic Wisdom. Today we are embarking on a deep dive into the very architecture of justice itself. We are analyzing the foundational constitutional decisions made by Hazrat Umar bin al-Khattab, peace and blessings be upon him.
That's right. And specifically, we're focusing on how he institutionalized the standards of evidence and testimony.
Our main source for this is, of course, Mr. Zahir Ahmad Mir's comprehensive book, The Foundation of Islamic Jurisprudence, Volume 1, Sub-Volume 3.
And we're moving past just the establishment of the courts themselves. We're looking at what makes them run the engine of justice, you could say, the rules of proof.
And our mission for this deep dive is to really understand how these early standards, which were established through decisions like Case 13 in the year 15 AH, how they became a kind of constitutional shield for society.
A shield protecting individuals from all sorts of things. False accusations, corruption.
And maybe most importantly, from manipulation by the elite. So please, do subscribe to our channel, like this video, and share it with your friends, because what we're about to discuss is, I think, so much more than just history.
Oh, absolutely. It's a blueprint. It's a blueprint for how a legal system is supposed to find and then enforce truth.
And why that truth needs constitutional protection in the first place.
The core of this analysis, and you'll see Mir emphasizes this heavily, is this recognition that the integrity of the judiciary entirely depends on the integrity of the facts presented to it.
Okay, let's unpack that core idea. Because usually when we talk about justice, we start with the judge.
Right. Is the judge pious? Are they fair? Are they neutral?
Exactly. But the source material here, it just immediately pivots to a much harder, more practical reality, which is that the court itself is fundamentally blind.
Precisely. A judge is human. They can't, perform mind reading. They can't see into the hidden intentions of the people in front of them.
Or magically know what happened weeks or months ago in some disputed event.
Not at all. So a judge's decision, it has to be limited. It can only be based on what's presented in the courtroom.
So testimony, documents, maybe an admission.
Or other verifiable proof. That's it. That's all they have to work with.
So the big realization by Hazrat Umar that seems to drive this whole case, Case 13, is that you can have the most righteous judge in the entire world. But if the foundation of their judgment, the evidence is rotten, then the outcome is going to be rotten too.
The whole thing collapses. The judicial system is only as sound as its weakest link, its weakest piece of proof.
This feels like a major constitutional pivot point.
It is. He'd already spent years securing the structure of the courts, making sure judges were appointed, they were paid, they were independent.
The framework was there.
The framework was sound. So once that was in place, he immediately turned to the content. What's actually happening inside those courts?
He understood that if you don't have standardized, objective rules for evidence, justice just stays arbitrary.
Right. It becomes totally subjective, vulnerable to local customs or, just personal influence.
It sounds incredibly modern when you put it that way. It's moving beyond just ensuring a judge is independent to making sure the whole system is competent in the face of deception.
It is. The central challenge, and this is really the aha moment that defines this decision, is crystal clear. If your standards of evidence are weak, justice just becomes an opinion delivered from a bench.
Just one person's feeling about the situation.
Exactly. And even more critically, if testimony is allowed to go unchecked, unchallenged, then the courts themselves become weapons.
Potent weapons for people who want to oppress others or just, settle old scores.
That is the crucial insight. A judge who's operating on unverified, easily manipulated proof isn't dispensing justice rooted in fact.
They're just dispensing personal preference.
Right. And if you allow that kind of unchecked testimony, the court, which is meant to be a refuge for the oppressed,
it risks turning into a legalized tool of oppression, used by the powerful or the vengeful or whoever can tell the most convincing story.
So the creation of these robust evidence standards, it's really an act of constitutional defense.
You're building a firewall.
A firewall. You're establishing truth filters designed to protect society from false accusations, from manufactured narratives, from emotional manipulation.
And from the elite, the governing class or the wealthy merchants who might otherwise just sway a system that's based on status alone.
So this deep dive is all about exploring how Umar created these rigorous defense systems for society. Systems that insisted that Proof, not opinion, not influence, was the only currency that mattered in a courtroom.
The source material is remarkably clinical when it outlines what's at stake here. It doesn't just say, oh, weak rules are bad. It details 4 specific systemic disasters that happen when a legal system fails to enforce these strict standards.
And that's because when the formal mechanisms fail, human nature just dictates a return to chaos, to personalized conflict.
Back to tribal justice.
Exactly. Back to revenge and self-help. Umar was consciously engineering a system to prevent that collapse of public faith.
Okay, so let's elaborate on these 4 systemic failures because they really justify the severity of the standards that he put in place. What's the first disaster?
The first one is false litigation.
Which is basically weaponizing the court itself.
Precisely. If it's easy to bring a weak, fabricated, or just a malicious case, and there's very little risk in doing so, people will use the system not to find justice, but just to harass their opponents.
Or intimidate them, or just drain them financially.
You can just exhaust them. You can imagine a scenario, right? A wealthy person can't win an honest dispute with a neighbor.
So they just file a frivolous lawsuit.
A frivolous lawsuit. It forces the weaker opponent to spend a fortune on their defense. The goal isn't even to win. The goal is destruction through process.
That's horrifying. It turns the court into a venue for vendettas.
It does. And it consumes huge amounts of the state's time and resources on claims that have absolutely no basis in fact.
And for the innocent person trying to defend themselves, the cost of justice just skyrockets, which is its own form of oppression, of ulm.
It is. A system that allows easy entry for baseless claims is intrinsically unjust.
Okay, so what's the second disaster? Because you said it was deeply corrosive.
This one is the emergence of witness markets.
Witness markets? You mean like literally a marketplace for false testimony?
Pretty much. This happens when proof is subjective or when a judge accepts testimony without any rigorous vetting of the person giving it.
So organized criminals, powerful landowners,
rival merchants, anyone. They realize they don't need truth anymore. They just need warm bodies, people who will get on the stand and lie.
So they just pay people, maybe desperate or marginalized individuals, to manufacture proof for any claim, no matter how false it is.
You've turned testimony into a commodity. It's for sale. And once the public perceives that the key element of evidence can be bought and sold.
How can any verdict ever be trusted, even a correct one?
You can't trust it. It destroys the moral authority of the entire legal system.
It creates a shadow system where facts are just negotiable.
And that leads us directly to the third disaster, which is the institutionalization of status-based proof.
So if the rules are weak or they're applied inconsistently, human bias just rushes in to fill that void.
That's exactly it. If there aren't strict, objective, standardized rules applied to everyone, a judge's discretion, well, it's inevitably going to be skewed by power dynamics.
Meaning the powerful, the well-connected, the high-ranking official, they're just automatically believed because of who they are.
Perhaps unconsciously, but yes. While the poor farmer or the traveler from out of town is inherently doubted no matter what facts they present.
So in a system like that, the word of a sultan is automatically fact just because he's the sultan.
Right. Even if his claim is full of holes. Meanwhile, the weakest person in society has to provide a mountain of unimpeachable proof just to validate a simple claim against someone powerful.
So the lack of standardized proof lets that institutional status bias become the ruling principle. It's not about what's true, it's about who you are.
And if you combine those 3 failures, courts, being used as weapons, facts for sale, justice skewed by status, you arrive at the 4th and final disaster.
Which is the collapse of trust.
The complete collapse. When the public sees that the courts are just for harassment, that witnesses are liars for hire, and that the outcomes only serve the powerful.
They just stop using the system. They check out completely.
They see the state judiciary as irrelevant, or even worse, as dangerous. And so they go back to settling disputes with violence or family feuds or tribal arbitration.
Methods that usually favor the strongest, not the most just.
The very chaos Umar was trying to escape. And it all highlights his foundational realization. You can't sustain justice just by hiring good judges. You need a constitutionally guaranteed integrity of proof.
Right. The integrity of the judge handles the ethical administration, but the integrity of the proof that provides the factual legitimacy. You need both.
Both must be rigorously enforced if the system is to survive.
This systemic fear of collapse, then, brings us to a core principle that the source material establishes. We can call it the gatekeeper principle. It's this declaration that the court's first loyalty isn't actually to the people arguing the case, but to its own integrity.
Yes, the guiding rule is very clear. The court's primary duty is to protect itself from deception, from lies, from manipulation, before it can effectively protect the people from oppression.
It has to be a firewall, an absolute firewall against falsehood.
It has to be.
And that's a really critical philosophical shift, isn't it? It reframes these evidence standards. They're not just some dry administrative rules.
Or what some modern critics might dismiss as technicalities.
Exactly. They are instead essential moral protection systems. Why is that moral dimension so important to stress?
Because if you just think of it as a technicality, you might argue for relaxing the standards to, speed things up. Let's make it more efficient.
Sure, get through the backlog.
But when you define them as a moral protection system, you realize that relaxing them is a guarantee of systemic injustice. It's about preventing the immense, society-destroying harm that comes from a judicial error. It's a defense of human rights at an institutional level.
Let's illustrate that destructive potential. We need to be vivid here to justify how stringent these rules were. What does a single false ruling based on fabricated testimony actually destroy in a community?
Okay, so imagine a business owner. His competitors hire 2 false witnesses to claim he defaulted on a major loan.
Right.
The false ruling leads to his assets being seized. His livelihood is gone, his employees are now jobless, his family is impoverished. That's economic destruction.
And what about reputation?
Even worse, in some ways. A false claim of dishonesty or some moral failure, if it's backed by what looks like proof, it permanently destroys a person's honor. They're aired.
They're standing in the community, and that's almost impossible to get back.
It's often irreparable. And in the gravest cases, we're talking about the destruction of life itself. The court has immense power to transfer wealth, dissolve families, even impose capital punishment.
So because the court holds this life-altering power, that power must be strictly constrained by verifiable truth.
Absolutely. If the system is seen as being cavalier about evidence, that destruction gets multiplied across society, and the court becomes an engine of state-sanctioned injustice.
Not justice.
Not justice at all. And that's why the stringency of these requirements for proof is a moral, constitutional necessity.
So to guard that gate, to filter out these potentially catastrophic lies, Umar established a very strict filter for the human element, the witness.
Yes.
This goes beyond just asking what they claim to have seen. It asks a deeper constitutional question. Who are you, and why on earth should we trust you?
And this shows such a profound recognition that human testimony, while it's the most common form of evidence, is also inherently flawed.
It's susceptible to error, to misremembering.
Or to just malicious intent. So the system has to assess the integrity and the capacity of the person making the statement before it accepts the statement itself.
Okay, let's dive into these criteria. Let's start with the bedrock, moral reliability, or ʿadālah. Now, this needs a deeper explanation than just honesty. What did it functionally mean?
ʿadālah means the witness has to have a recognized standard of moral and religious uprightness, but specifically as it relates to trustworthiness in public life.
So it's not about being a perfect saint.
Not at all. It's about being known as reliable. The source is explicit about the disqualifiers: being a habitual liar, known corruption like taking bribes or cheating a business, or engaging in openly shameless or reckless public behavior.
So the judge isn't just assessing the witness based on their performance on the stand. They're looking at their life history.
That's it. If a merchant is known throughout the entire marketplace for routinely shortchanging his customers, can you really trust him to be truthful in court?
The pattern of behavior suggests no. He prioritizes self-interest over truth.
Exactly. And this is crucial. The clarification from the early jurists, following Umar's standard, was that the goal here wasn't to police private piety. It wasn't about sins that were not public knowledge.
A person's relationship with God is their own business.
It's separate. The goal was to ensure the witness was trustworthy in public dealings. That's the key. It's about their functional reliability within the legal framework.
That distinction is so vital. It's a system focused on functional reliability, connecting moral character directly to legal competence. Does this have a modern parallel?
Oh, absolutely. When we vet jurors today, what are we looking for? Impartiality and reliability. When we consider the testimony of an expert witness, we scrutinize their professional background, any history of ethical violations.
So ʿadālah is like the foundational requirement for a credibility assessment.
It is. It ensures that the history of the witness aligns with the gravity of their role in establishing a legal fact. If the witness has a known motive or a history of deceit, the court simply cannot fulfill its duty to find the truth.
Okay, moving to the second criterion. Mental soundness and understanding. This sounds obvious, but what did it require in a sophisticated legal sense?
This criterion is all about capacity. The witness has to be intellectually and psychologically capable of providing reliable testimony.
Which requires a few things, I imagine.
It requires three things, really. First, they had to have understood the event when it happened. So they couldn't have been, say, extremely intoxicated or unconscious.
Makes sense.
Second, they must comprehend the statement they're making in court. They have to be articulate and mentally present. And third, and this is critical, they must not be easily confused, manipulated, or subject to some severe cognitive impairment.
So this filters out people who might be honest, but they just lack the capacity to accurately perceive, recall, or relate complex events.
Yes. And this is why testimony from people with severe mental incapacities or, certain testimony from very young children was treated with extreme caution. It required extensive corroboration, if it was accepted at all.
The court recognized the immense danger of basing a life-altering judgment on unreliable perception or memory.
Of course.
Then we get to the third, and maybe the most complicated criterion, freedom from bias. How do you even begin to regulate an inner state like bias to make sure testimony is pure?
This is where the judicial inquiry gets really sophisticated. Testimony is basically deemed worthless if it's visibly or demonstrably contaminated by personal interest.
And that includes both conscious and unconscious motive, right?
It does. The court has to actively look for evidence of self-interest in the outcome.
So what are the clear disqualifiers listed in the source material for bias? What's a red flag?
The first one is direct financial benefit. If the plaintiff wins the case, and as a result the witness stands to immediately gain money or property or have a debt canceled.
They're disqualified. Their impartiality is shot.
Completely compromised by a clear vested interest. The second is extreme personal vengeance. If the witness has an explicit, documented history of hostility towards the accused,
They're known enemies or rivals.
then the court has to guard against testimony as revenge.
But wait, how do you prove vengeance? I mean, doesn't asking a judge to read someone's deep-seated resentment risk giving the judge too much subjective power again?
That is the precise challenge, and the jurists addressed it by relying on public knowledge. The bias couldn't just be a feeling the judge had. It had to be generally known or established through independent inquiry.
So, for instance, if the witness had recently filed another totally frivolous lawsuit against the accused,
Or publicly threatened them, that establishes known hostility. The court isn't guessing, it's documenting established behavior that points to bias.
that shows such profound psychological insight. The court has to filter not just deliberate lies, but also truths that have been warped and distorted by hatred or jealousy or greed.
It's to ensure the evidence is presented for the sake of justice, not for the sake of winning a feud. These three requirements, moral reliability, capacity, and impartiality, they form this rigorous human filter that makes the whole legal system viable.
So once a person is even qualified to testify, the court's job is only half done.
Not even. The system then moves to the second layer of protection, verifying the witness's character and also the internal integrity of the story they're telling.
Okay, let's start with that revolutionary administrative mechanism, witness verification, the birth of the character inquiry. This standard says a judge can't just accept a witness on face value.
This is a proactive constitutional defense against that witness market disaster we talked about. The judge actively initiates an inquiry. Who is this person? What's their reputation in their community? Do they show up in court a lot?
So the judge, or maybe judicial officials, they're conducting a discrete background check.
They're often querying community leaders, neighbors, business associates.
This sounds like the early model for modern due diligence and credibility assessment. How effective was it at stopping people from just manufacturing witnesses?
It was highly effective. Because if a claimant brought in two witnesses who looked perfectly respectable on the stand, but the judge's inquiry revealed they were, say, recent arrivals with no established reputation,
Or worse, they were known associates of the claimant with a history of shady deals.
then the judge had a constitutional basis to just reject their testimony outright. It forces the person making the claim to rely on verifiable community members, not hired guns.
That puts the burden back on the claimant to bring genuinely reliable people to court, not just people willing to say what they're told.
Absolutely. Now, from there, we move into the actual structure of the evidence itself. Consistency and detail, what the source calls the structure of truth.
This recognizes that truth has recognizable markers and fabrication. Well, it often breaks down under pressure.
Exactly. The source material highlights that truth is consistent. It doesn't change core facts. It is coherent detail. The narrative holds together logically.
And it maintains a stable narrative. It doesn't shift around when you start asking tough questions.
Whereas liars, who have often just memorized a script, they really struggle to maintain that consistency in detail when you pull them off that script.
So the judicial process itself becomes this sophisticated stress test for truth. How did the early courts actually conduct this test?
They used careful, focused questioning. A key technique was separating the witnesses and then checking for contradictions in the granular details.
So if two witnesses claimed they saw a contract being signed in the market,
The judge might ask the first one, okay, what was the weather like that day? What was the scribe wearing? How many people were standing nearby?
and then they'd ask the second witness the exact same questions separately.
Right, and if the stories diverged significantly on non-essential details, it might just indicate poor memory. But if they contradicted essential facts, or if one witness just completely changed their story under pressure,
It signals fabrication,
Yeah.
and their reliability plummets.
it requires judges who are skilled not just in reciting the law, but in the psychological dynamics of memory and deception. They have to be expert listeners and questioners.
And I imagine as the Islamic administration expanded, the need for written records became more and more important. Which brings us to documentary evidence.
Yes, we see the transition from a purely oral legal tradition to a system that acknowledges the administrative necessity of a paper trail.
Especially for things like property and big commercial transactions.
Precisely. Umar's governance encouraged written contracts, registers, official correspondence, especially as taxes and land ownership became more formalized. And the courts took these documents very seriously.
But I suppose a piece of paper can lie just as easily as a person can.
Of course. So judges were required to verify the authenticity of all documents presented to them.
How was that authenticity ensured back then?
It relied on two key factors: official seals and scribal standards. Official documents had to have the recognized seal of the governing official or the treasury.
And for private contracts.
For private contracts, the judge would have to verify that the document was either written by a recognized upright scribe or attested to by qualified witnesses who could confirm the signature and the circumstances of the writing.
So you couldn't just produce some random contract written by an unknown party.
No. This verification standard was essential to prevent document forgery from completely undermining property rights. It laid the immediate groundwork for documentary governance in law. Powerful, but still subject to the same constitutional standards of verification as human testimony.
Finally, let's look at the evidence hierarchy, the system of proof versus oath. It seems it was structured to make sure clear proof is always the most important thing.
To prevent courts from becoming places where people just swore their way out of trouble.
So what was the clear order of precedence that was established?
The primary tier was clear proof. This included qualified testimony, authenticated documents, and, most powerfully, an admission by the party themselves. If clear proof was presented, the case was decided based on that.
And what if that primary proof was, just not there, or it was insufficient?
Only then was the oath applied, and typically it was applied to the denier, the defendant.
And the source is clear that the oath was not a substitute for evidence.
Explicitly clear. It was a procedural closure mechanism. It was used when verifiable facts were reasonably unavailable just to prevent disputes from lingering on forever.
So that's another constitutional barrier.
Right.
By strictly limiting the oath, Umar prevented the courts from turning into oath factories where evidence could just be bypassed by a sworn statement.
The evidence, the verifiable facts, had to be the absolute foundation of the system, period.
This brings us back to the big picture. Why did this case, Case 13, rise to the level of constitutional significance? It's because these rules aren't just technical procedures, they are fundamental safeguards for the stability and morality of the entire society.
And the first and most critical societal safeguard is the protection of reputation, or word. Umar recognized the immense value of honor in Islamic society. Unlike your money or your property, your honor, once it's destroyed by a false allegation, is almost impossible to get back.
We often think of justice systems as protecting life and property, but here the system explicitly aims to protect reputation as a constitutional right, placing the burden of proof incredibly high to prevent its casual destruction.
That's it. Evidence standards constitutionally shield your erd. A claim made in court that attacks a person's integrity or their morality without verifiable proof is defined as chaos. If anyone could just destroy someone's reputation on a whim, the social contract breaks down.
So the standards demand that honor can only be taken away if the claim is backed by the most rigorous, verifiable facts.
This is so relevant today, isn't it? With trial by rumor and social media accusations that can just dismantle a reputation in an instant, Umar's standard insists that due process has to apply to your reputation just as strictly as it applies to your property.
Absolutely. The system mandates a pause, a verification, a standard of proof. It resists that emotional urge to condemn someone based on hearsay.
The second major safeguard is aimed directly at the structure of power, preventing elite manipulation.
As the state grew in wealth and territory, power became more centralized, and the challenge of powerful figures trying to subvert justice must have become acute. How did they try to do it?
They used sophisticated tactics. They'd bring in influential witnesses whose status alone was meant to impress the judge. They'd apply political or financial pressure, or they'd mobilize their tribal networks to back a dubious claim.
Essentially trying to substitute influence for proof.
Yes, and the strict standards of evidence were the tool to neutralize that threat.
Because they ensured absolute equality before the evidence.
The rules are clear, and they can't be bent based on your rank. Proof is required no matter who you are. The witness has to be credible, not just powerful. And the judge must be insulated and diligent enough not to be impressed by status.
It's the ultimate equalizer. The standards force the powerful, the rich, the politically connected to meet the exact same threshold of verifiable fact as the poorest, weakest member of society.
And this leads directly to the ultimate constitutional truth here. The rule of law realized. The whole concept of rule of law is just an abstract idea until you define the actual rules of the game.
It's easy to say you have a court system, but unless those courts are bound by an objective, disciplined procedure for determining facts, they're just tools of the state or the elite.
Umar's evidence standards cut right through that facade. They ensure that courts decide by verifiable proof and disciplined procedure, not by favoritism or fear or financial pressure.
It institutionalized the pursuit of truth,
making judicial outcomes immune to political convenience and securing the system's legitimacy in the eyes of the public.
So if we pull back and connect these standards to the history of law around the world, what we're seeing is a remarkable, very early articulation of principles that are still foundational to modern law.
It's a foundational ethical legal blueprint. We can draw a direct line from Umar's standards to modern evidence law. He created the early ethical basis for so many key concepts.
Okay, let's break down those parallels for someone learning about this today.
All right, take witness competence. This corresponds directly to his criteria for mental soundness. Modern courts are constantly assessing if a witness is capable of understanding the oath and relating facts accurately.
Okay.
His concept of credibility rules is what we see in modern voir dire jury selection background checks, conflict of interest disclosures. His requirement for documentary authentication is essential in every single commercial court in the world today.
And the burden of proof.
And the burden of proof, the hierarchy he established, is fundamental to determining who has to prove what in any legal system.
So he wasn't just building a dry bureaucracy, he was building these incredibly sophisticated justice safeguards.
The goal was to protect the innocent, to ensure that the mechanism for resolving conflict was robust and fair. And this is vital. These rules were conceived as a shield for the innocent, not just bureaucratic hurdles.
The idea being, if the state is going to wield the power of judgment, it has to earn that right by following an unimpeachable process of factual verification.
And this brings us right to today's landscape. Our contemporary world, with its information overload, seems to be collapsing back into the very disasters Umar sought to prevent.
We're fighting a modern version of the witness market. We're facing the challenge of deepfakes, digitally fabricated evidence.
Where proof can be manufactured with an ease that is just unprecedented. And we are inundated with social media accusations, trial by rumor, where reputations are destroyed instantly without any constitutional standard of verification.
And we absolutely suffer from a politicized witness culture and just rampant character assassination, where the goal is victory at any cost, regardless of the integrity of the facts. The integrity proof is maybe more fragile today than it was in 15 AH.
Umar's model gives us clear, timeless lessons for navigating this chaos. It mandates that verifiable truth, subjected to rigorous vetting, must remain the prerequisite for any claim to legitimacy. If our courts, or even just our public discourse, abandon that rigor, we instantly risk falling back into those four disasters.
So what are the essential, actionable lessons from this deep dive that we can apply today? Let's say 4 key takeaways.
Okay, first, all claims must have verified proof. An assertion, whether it's in a boardroom, a courtroom, or on social media, is fundamentally meaningless until it is supported by established, vetted fact. We have to maintain a constitutional skepticism.
Second takeaway.
Witnesses and sources must be thoroughly vetted. We have to constantly question the source, the motivation, the capacity, the bias of anyone presenting information. Who is telling me this, and why should I trust them?
Third, we must prioritize the protection of reputation. Our eared. We have to resist the casual, rapid destruction of honor that happens through unverified claims, recognizing that this has a massive, often irreversible societal cost.
And finally, and this is the big one, strong discipline standards for evidence are a fundamental human rights protection.
They're the constitutional shield.
They're the shield that protects the innocent from malicious prosecution, political opponents from smear campaigns, and the vulnerable from the manipulative power of the elite. These standards, established so early on, remind us that rigor isn't an inconvenience. It's the prerequisite for justice.
And that's really the powerful conclusion we can draw from Case 13. Hazrat Umar built a judiciary that was designed to chase verifiable truth, not popularity or political convenience. He made sure the integrity of the process was more important than the status of the people involved.
He understood that if the evidence is sound, if it's past all the filters for capacity, reliability, impartiality, then the verdict is legitimate and must stand, even if it's unpopular with the crowd or inconvenient for the powerful.
But if the evidence is weak,
If the evidence is weak, then no matter how politically convenient the outcome might be, the verdict is illegitimate. It's destabilizing.
So the most profound takeaway for any society, modern or historical, is that the first victim of weak evidence standards isn't the accused or the liar or the victim.
It's society's belief in justice itself.
When evidence is strong and rigorously vetted, justice becomes fearless.
It doesn't fear being challenged or proven wrong because its foundation is verifiable fact. But when evidence is weak, justice becomes a rumor. It's suspect, it's fleeting, and it's based on who you know or what you believe, not on what you can objectively prove. The true strength of a state is shown by its willingness to uphold truth, even when truth is hard to find.
This deep dive into the institutionalization of evidence provides just a timeless framework for any system of governance that's seeking integrity and how it resolves conflict.
And this commitment to institutional integrity, it extends beyond the facts themselves to the individuals who have to weigh those facts.
Right. So next time we're moving to a related issue of independence that's crucial for maintaining these very standards.
We'll be looking at Case 14, concerning the judicial salary independence system. We're going to ask why judges must be financially insulated and well compensated to protect them from the very manipulation, bribery, and pressure that these strict evidence standards are designed to expose.
The system has to protect the proof, and it has to protect the people who weigh the proof.
The proof weighers, exactly. Join us then for another deep dive into the foundations of jurisprudence.